Good afternoon, everyone. Thank you very much for joining us today. You've got myself here, Kaylee Swift from NB Property Law. I'm one of the directors, and then we've got Sloane Wilkins, the executive financial coach. We'll introduce ourselves in a minute, but essentially our webinar today is all about how financial wellbeing influences testamentary trust and tax planning decisions. So I just wanted to introduce myself first and the NB Property Law team. So essentially, I specialise in commercial residential property matters, and I also bring a broad experience from both private practice and also local government. So I advise on complex leasing, acquisitions and property development projects, but also I have a vast amount of experience in estate planning, estate administration and probate matters. I'm passionate about delivering practical, commercially focused advice that supports my clients' businesses and also their personal growth, while also ensuring smooth transactions for them. NB Property Law is part of the wider NB Law Group, where we have NB Commercial Law, NB Employment Law, and also NB Migration Law. And I'll pass over to Sloane now to introduce himself. Thank you, Sloane.
No worries. Thank you. Good afternoon, everyone. My name is Sloane Wilkins. I operate as an executive financial coach. I am based here in Brisbane, but able to serve clients wherever they are, in fact, around the world, as long as the internet connection is good. And my background is 30 years in banking as well as wealth management. So I spent more than half of my career taking care of high net worth clients. So these days I focus on supporting both professional people and business owners, sometimes both in the same couple, and really helping them to bridge that divide from where they are today to how they would rather be living their life, and particularly when it comes to success with business as well as in their careers, it's translating that success into developing sustainable and secure wealth for them personally. So I love working with and supporting all those people. Thank you, Carly.
Wonderful. Thank you very much for that, Sloane. So essentially what we're going to run through today is how testamentary trusts actually operate and when they are effective. We'll be talking about tax efficiency, control and flexibility for beneficiaries. We'll go through the key considerations in estate planning and dealing with deceased estates. Sloane's going to speak a little bit about how financial clarity and behaviour can influence planning decisions, and then he'll finish up talking about aligning financial priorities with legal and also estate planning strategies, which I'll be going through. So to start off with, the first one is, what is a testamentary trust? So it's, everyone knows essentially what a will is, but testamentary trust is a little bit more advanced in terms of just a basic estate plan. So a testamentary trust is a trust established within a will. So it does not come into effect until the actual death of the testator. So the testator is the actual person that's making the will. So within your will, you'll be appointing a trustee who'll be responsible for the management of the testamentary trust. So yes, they're responsible for how the testamentary trust is managed, but also that trustee of your estate is responsible for other things. So, things such as, everything. We often know them as a trustee, administrator, or an executor. So they do, essentially, as the name suggests, all the admin things as well, such as, obtaining death certificates, dealing with, talking with us as lawyers to arrange for probate administration and things like that. You can have multiple testamentary trusts as well within one will. Example of this is you may, for example, want to you might have elderly parents that are still alive that you're wanting to supplement their pension with a particular amount per month or fortnight, whatever it is, and then separately to them you might be wanting to do something completely different with your children. You might want to be giving them a deposit for their first home, which maybe they can get that when they're 25 years old, 30 years old, for each of your children, and then maybe once they're 35 years old, they might be entitled to receive, a second deposit for a house or something like that. So there's different reasons, why we have testamentary trusts and how they operate. And then obviously, as I mentioned, there may be as well multiple testamentary trusts as well within the one will. So you do need to specify the asset and the property that are going to be included in the testamentary trust. So sometimes it's not just cash, which are, were kind of the examples I was giving then, but sometimes there's actually assets. So, for example, there might not be cash that you're giving the children to buy property. It could be that there's properties that already exist. You may own, multiple properties, or, it could just be one or two, whatever it is, that you're essentially putting in the trust, and the trust is essentially going to hold that money. So, or that asset. And with the testamentary trusts, they're done for a range of different reasons. Sometimes they're, as I said, to drip feed money to particular people. Sometimes it's more asset protection. Sometimes it's for tax reasons. In terms of like asset protection, sometimes we've had clients come to us where they've got children that are potentially looking to, they might have relationships with their partners that are maybe in the infancies, or they're not happy with the choice of their partner, and they're worried about their assets essentially ending up, if that relationship turns sour, that those assets then could be divided equally, or somewhat split with that in-law that they're not overly happy with at that point in time. We've had clients do them for a range of different reasons. Sometimes it's been that they've got a disabled child, so that they don't want the disabled child to receive a full inheritance upon their death. They want to make sure that disabled child is looked after, cared for, and the way that they do that is through this testamentary trust. So a range of different reasons as to why they're done. We take our clients' instructions, and we try and guide them. Often they've spoken to someone like Sloan, or potentially their accountant, or they've spoken to other professionals, and then they've come to us with what they think is the solution, and we will guide them as to what we can do and how we can do it. And sometimes the testamentary trust is the way forward with that. So I've spoken a little bit now about when you should include the testamentary trust. Like I said, often it's when beneficiaries are young, so like children, they're underage. Like I said, you don't want them receiving a full inheritance of whatever your estate is worth at such a young age, where they haven't even finished university or anything like that, and you're worried they're going to essentially blow that inheritance. The other example I gave was a disabled child, or someone that's got special needs, that we're worried just needs a bit of extra care, and want to make sure that money's protected to look after them for the entire lifetime, as opposed to just being drained immediately. Another example is if the beneficiaries are financially irresponsible. So that could be for a range of different reasons. Sometimes, in families that there's issues, whether it be abuse with substances or something like that, or just simply that a child just doesn't have the financial capacity to be able to deal with big sums of monies. Another example is actually to protect the assets from bankruptcy, or divorce was kind of the other example I was leading to before, when I was speaking about in-laws having access to that money if there was a breakdown in that matrimonial marriage, or civil partnership, or whatever that may be. It doesn't even necessarily need to these days, to be considered a de facto partner, necessarily need to even be married, or a registered civil relationship, which is sometimes where the risk can arise. The other example I mentioned was, obviously tax advantages, but also just to preserve the assets for your children, while allowing your spouse to also benefit from the estate. So, definitely not an exhaustive list here, and it's obviously quite specific, but there's many examples that I could give, but it really is treated on a case-by-case basis, depending on what your needs are, as to whether a testamentary trust is the right solution, and and then B, how we go about implementing it, and whether it is just one testamentary trust or multiple trusts that we do need. Many advantages obviously come with having a testamentary trust. The one I mentioned is, we're doing it for asset protection. So the assets that are held in the trust, they're not actually dispersed directly to the beneficiaries. The assets are actually protected from creditors then, or legal disputes, and obviously potential family law claims, as I mentioned, divorces and things like that. So that does provide a great level of protection for your assets, which, provides peace of mind essentially. So we want to, making sure that everything is going to who we want. And sometimes, although we've just got a standard will with beneficiaries listed, it doesn't always do that. As I mentioned before, if we do have children, they end up marrying, that relationship breaks down, that in-law could become entitled to some of that asset pool. Obviously, creditors in terms of businesses, if we're providing personal guarantees and things like that, business goes sour, banks and creditors are going to come after anything that is personally owned as well. So, a range of different examples that we could go through there, but essentially, the main thing to note is, it does give that asset protection. Also, another advantage is, the tax advantages. So the income can be dispersed in a tax effective manner through a testamentary trust. So, I'm not an accountant. I'm not going to be providing accounting advice. Sloan will probably be touching on this a little bit further, but it is, important to know that it is seen as a tax advantage, and obviously you can speak, to the likes of Sloan or your accountant in conjunction to work out what type of advantage that would have for you. The other thing is flexibility, but more control. So this is what our testamentary trusts are providing. So the trustee essentially will have the flexibility on how to actually disperse the income and capital, but you can still control how the funds are to be used. So, like I mentioned in that example before of gifting the children a certain amount of money at a certain age to buy a house. So, it can be quite specific. And obviously, if the children decide not to do that, they don't get the money, that the money will stay within that trust. And, then there'll be the next step of when they're going to get money and stuff like that. So instead of an actual lump sum just being given to children, the funds can essentially be dispersed gradually or under specific circumstances, which is sometimes what you want as a testator, to know that your assets are being used to the benefit of the beneficiaries, or the beneficiaries of that testamentary trust, and how you intend for them to be used, rather than just being all given to the beneficiaries at once, and not having anything to show for that money essentially. Obviously, with any advantages, there's always disadvantages or cons of a testamentary trust. The ones that we've got listed here is that it can be a bit more complex than a standard will. So your standard will is standard, it's basic, it doesn't go into too much detail, and it's not meant to. So essentially, with a will, the intention is that everything is dispersed, essentially once if probate is needed, and there's no disputes or anything like that, the money's all dispersed. There's not a matter of drip feeding money or anything like that. The only limitation to that would be for children when they're under the age of 18, and if guardianship provisions were included in that will, then obviously the money would still stay in the estate account and just be drip fed to the guardian to clothe, food, educate the children until they reach the vesting age, which is essentially the age at which they would then inherit the remainder balance that they're entitled to as beneficiaries under the will. So yeah, it is more complex than the standard will. It therefore requires careful consideration and expert advice to ensure it's drafted correctly. So a lot of people go along and get their DIY, we like to call it, will kit from the post office, or they've found one online, and these days there's a lot of AI and things out there. Definitely wouldn't recommend it with even a will, but definitely not with a testamentary trust. There are a lot of considerations that need to be thought about and included to carefully draft that document, to make sure A, that it's legally binding, and B, that it actually is tailored to your needs. Like, what you have could be completely different to what, a family member, a neighbor, or someone like that you've spoke to that's got one has in place. You could own, a lot of different asset classes, businesses and stuff like that, and you want them to be, distributed or something differently. The other disadvantage would be obviously higher costs. There's a lot more involved, as I said, in terms of careful consideration, us giving expert advice and making sure that we're spending the time needed to properly draft the document, which is very tailored and very specific to each individual's needs. So we need to make sure that obviously that's reflected correctly in the investment that you're making, which, the costs, it is then essentially going to cost more to establish, and there will be ongoing administration costs as well involved in that from the accounting point of view, if once the testamentary trust comes into play, which is once the testator actually passes away. The thing is that it can be time consuming as well. So, it's taking a lot of time for us to seek the instructions, to make sure that we've carefully considered the advice that we've given you, and that you then provide us with the adequate instructions to go away, draft the document, we'll send it to you, make sure is it exactly what you wanted. That might trigger some further tweaking and things like that from your point of view. So, it's an ongoing, administration. There is more time involved in actually managing the estate as well when there's testamentary trusts involved. It's not just, like I said, with a normal will, all done and dusted, soon after probate is granted. The other issue of a disadvantage could be the potential for disputes with the trustee. So if the trustee essentially mismanages the funds or breaches their fiduciary duties as a trustee, then the beneficiaries can have legal grounds to actually sue the trustee. So it's really important that who we're appointing is as a trustee for the testamentary trust or for our estate is someone that we definitely trust in this role. And hopefully, they're going to do the right thing and not mismanage the funds in that estate. There are grounds obviously for the beneficiaries to deal with the trustee if they don't do that, but it is really important to get that decision, right at the outset. Obviously, people change, money makes people do, strange things sometimes. But hopefully, you've had a good think about who's that person's going to be before deciding to appoint them as the trustee for the testamentary trust or multiple trusts if there are. So what can a testamentary trust include then? So it can include layers of beneficiaries. So the primary beneficiaries, generally in a normal, somewhat situation, it's generally going to be the spouse. And then if they've got children, even if they're unborn children, we can list them as unborn children, and potentially any grandchildren or unborn grandchildren. The secondary beneficiaries can be that they're the first layer primary beneficiaries, but then secondary would be that children or grandchildren, or if they don't exist, it could be even siblings sometimes listed. So it depends on specific circumstances as to who those people are going to be, as to who we list in there. Now, is there a limit then on what can actually be dispersed with a testamentary trust? So you can include direction that the trustee may be able to release the income, but you will be unable to actually disperse the capital until a set date. So with the estate, obviously, we need to make sure that everything is done in terms of, winding up and, applying for probate and things like that. And then likely potentially within the testamentary trust, there may be certain dates and key points that are listed as to when, funds are being dispersed. For example, that could be a potential age limit of the children, so them or the grandchildren reaching that particular age point, or it could be based on an event. You might want to gift each of your 4 children $100,000 towards their wedding, whatever it might be, or the grandchildren. And obviously, so, the date that money would be dispersed would be, the trigger of that event. The other thing to think about is provisions for future generations. So I mentioned a vesting date before in terms of the actual will. The vesting date, though, for testamentary trusts, this date can be up to 125 years. So that's generally, the date that basically, it's ensuring that the future generations, so obviously we've got those primary beneficiaries, which may be the spouse or the children, but even then the secondary beneficiaries, so the grandchildren, they've received essentially essentially all the inheritance, and essentially by 125 years, there really should be no money left in the estate, and the trust would then vest at that point in time. So can a testamentary trust actually be contested then, like a will? The short answer is essentially yes, it can be. As a testamentary trust is part of the will, it can be contested if a person has grounds to do so. So the grounds for appealing, like a will, the same as a testamentary trust, so could be through a family provision application. So you'd be applying to the court if you are, family member, potentially a dependent of the testator. So, for example, if for whatever reason, the spouse or the children, grandchildren, or whatever, were not happy with what had been, left to them, what their inheritance was, or how it was being, gifted, or when it was being distributed to them. Maybe they weren't happy with, only getting a portion of that money at whatever 50 years old or something like that, and they thought they should have it at 30, whatever. They may be, appealing that. The good thing though is obviously having it properly drafted. We've taken things into consideration to properly draft and outline what the intentions and the legal intentions are of the testator. So when we're then going ahead and dealing with litigious claims, we can obviously hopefully overcome most of them through providing the courts with the reasoning as to why certain things were done a certain way. Other grounds for appeal would be if the actual testator didn't have capacity at the time of making the testamentary trust. So if one of the family members is contesting that they didn't actually even have the capacity to make it, maybe they were under next point is undue influence or coercion, whether there was any fraud or suspicious circumstance involved. From time to time, you probably hear in the media about situations like that, where, one family member's conspired against the other to, make the elderly mum who's, probably somewhat, got dementia or Alzheimer's or something like that, and gone and changed the will at that point in time to, maybe write out, siblings or something like that from the will. If that can be proved, obviously that's, grounds for the appeal, and then, could be successful if that were the case. So, like I said, short answer, yes, can be appealed, in terms of the grounds for it. Family provision applications, lack of capacity, undue influence, but it really is, again, case-by-case basis as to, what the prospects of success of that appeal is. And, one of the key points for us is making sure that we've really tightly drafted that testamentary trust and the will attached to it, so that we can clearly outline for the courts, why it's been done in this way. Sometimes we even need to attach statutory declarations as well from the testator to approve, and why they've, sometimes there's a breakdown in relationship with, their child, and they're estranged from them. We would include, a statutory declaration about that to say that, yes, we know we have this child, they're a legitimate child of mine, for whatever reason they've gone and changed their surname, haven't had any contact with them for 40 years, they've told you they didn't want to have anything from you, and that's why they're not included in the will, things like that. So continuing on with the grounds for appeal, so the family provision application. So this is often the most common type of claim that we see. So if a will does not adequately provide for, a child, a spouse, or financial dependent, that person's going to have the grounds for appeal. Like I said, there could be many reasons for that. The one I alluded to before was, maybe they were estranged from the family member for different reasons. So, in terms of reducing that risk, obviously a good way to do that is by having, we've got it listed here as a statement of wishes that explains the reasoning behind your decision. But like I said, we take that one step further and actually draft it as a statutory declaration, that the testator is, confirming that they definitely did not want them included in there, and the reasons for that. So, not having that, it just opens the door and opens a can of worms to essentially mean that the appeal could be successful. So that's why, essentially you're paying a little bit bit extra to make sure it's been clearly drafted to adequately protect your assets and who you wish for them to go to. It is important though to make sure that your will's kept up to date. So there's no point in having, your will and testamentary trust drafted and then sitting in a cupboard, forgetting about it, locking it away for the next, 20, 30, 40 years. And all of a sudden, maybe you've lost capacity and can't even make a new will. And all of a sudden, people are scrambling to find it. They might not know where it is. It could be damaged. The people all listed in it could be passed away, whatever it is. So we always say, have a look at will every 5 years and testamentary trust, and then also, on certain events and circumstances. So, if there is a death of someone that's listed in your will, if you've, remarried, if you've divorced, if you maybe come into a big sizable chunk of money or inheritance or assets or something like that, and you therefore need to maybe distribute it a bit further rather than just the specific beneficiaries you've got listed, whatever it might be. The statement of wishes that's listed here, it is just that, it's a statement of wishes. That's not necessarily binding, but it still can help to outline exactly what it was that you were intending to do with your estate plan. The last one is include testamentary trust, which will allow the assets to actually be dispersed over time, which is, like I said, that's the advantage of having the testamentary trust. It really does outline, for the courts exactly what your intentions were. And if it's been drafted correctly and adequately and correctly signed and witnessed, that goes a long way in these appeals that the courts receive. Continuing on with the grounds for appeals, so the lack of capacity. So, there's a basically talking about, mental capacity to actually be signing off on the will. So this is often raised in conjunction with a family provision application. So, it generally is, a sibling, a spouse, or someone like that making the appeal under the family provision application. But then they're going one step further as well and saying that the testator didn't have the capacity to be making the will. So essentially, a will is presumed valid as long as it meets the formal legal requirements, but there is evidence that the person did not have the legal capacity at the time of signing this, then it can be overturned under that presumption. So the best way to avoid this is to ensure that the testator has a letter from their doctor and they have the will prepared by a solicitor who can actually meet the testator's requirements in terms of proving that they've got the legal and mental capacity to be signing off on that will. That's particularly important, like I said, in older people, or if someone has had a medical episode and been in hospital for a period of time, just to show that they've got capacity, and that can't be then relied upon as a successful grounds for appeal. Other grounds for appeal is, as I mentioned, undue influence. So this is talking about if a testator essentially it has a vulnerability of a person and they could use their power to control the testator. So this is beyond guidance and involves coercion or exploitation of a power imbalance. This could be, for example, where you've got maybe it could be someone like a carer that is coming in caring for the testator for a number of years, and they are essentially coercing them under the influence to basically make sure that they mend their will so that the carer gets a large portion of the estate or something like that. That's just one example, but there's multiple examples like that. The possible indicators then for grounds of appeal are, if the will has been changed dramatically without clear reason, that's a warning sign. If the testator is unable to actually express why they want the changes, so if someone's coming to us and they can't tell me why they want to do that, that's ringing warning bells for us, and we're obviously questioning a lot more. And in some situations we may say we can't act for you because we don't think that these are your actual intentions and wishes. If the testator is unable to meet with us as a solicitor without another person being present. So if they are, telling us they need to have, this friend come along, and we think, this friend's a bit of a mouthpiece, then we're not going to be acting because we don't want it to end up in an appeal. So what steps can be taken then to reduce the claims of undue influences? So essentially ensuring that any changes you make are explained properly to your solicitors. So we can take those instructions, we take file notes. If it does get appealed, we can rely on them. Making sure that you're meeting with your solicitor independently. Sometimes it might be, a spouse, but, we don't want, potentially some other person that's completely, not generally someone that would be included as a beneficiary or something like that in the will, or, a spouse, like I said, a friend, or, carer, whatever it might be. Making sure we get that statement from the GP for legal capacity, especially if there has been medical episodes or the person is getting quite old and frail. Also writing a letter explaining why you've made changes to the will. So, that could be, email to us as the solicitors outlining, what is the reason behind you wanting to all of a sudden make these drastic changes. So that's kind of covered off on me and testamentary trusts, how they operate, what are the advantages, disadvantages, and then, how they can potentially be appealed, and obviously the strategies we have for potentially overcoming those reasons. So I'm going to pass over to Sloan now to talk to you all about, financial well-being influences and, testamentary trusts and planning decisions around that. So I'll hand over to you now. Thank you, Sloan.
Thanks, Kaylee. It's such an important area to be thinking about. And from a family perspective, and definitely when I'm talking with clients, the key elements that we always work through when we're talking about finances or their estate planning is helping them to be exceptionally clear so that they are able to enact those wishes and direct their assets and their income as appropriate. So let's jump in and I'll share you a little bit more. So of course, if we go to the next slide, I can move it myself. Excellent. So legal structures, of course, are incredibly important. They are just the start, and it means that we do need to have some effective estate planning in place. So that is following up the disciplined financial behaviours that we will have. We will, of course, need that clarity that comes next with the clarity of capital that determines how flexible we need things to be for the future generations to follow. And of course, as Kaylee was referring to, the needs of those individuals where they are known are incredibly important. And that can be medical conditions, it can be mental capacity, it can be lifestyle decisions that are being made that perhaps will be exacerbated if we give them large amounts of capital. And finally, look, legacy is one of those things that we can create even while we are still here. It is not one of those things that only comes into being when we pass away. That's when we hope it will continue. However, it's up to us today to make sure that we've got those legacies, those family traditions, those personal values being lived out by the people that we hope to support into the future. So documents can definitely help, but the work that we can do individually with our family members and those we hope to support while we're still here is so valuable in that regard. Next, when we look at financial clarity, that is what I feel actually delivers most of the value when we get to estate outcomes. The documents are so important. We do need, however, just to make sure that we've got that clarity, because when we've got a precise understanding of those assets, liabilities as well, where the income is flowing from, and all the other exposures that we might have from a financial perspective, that allows our estate planning to be as proactive as we can possibly make it, rather than being corrective and trying to fix things from beyond the grave. So strong financial visibility enhances the quality of the legal structuring, and it's definitely worthwhile getting a clear picture of what we want to achieve, but where we are today as we move through the process and start to engage with specialists like Kaylee. So long-term orientation, when we think, however, of short-term financial decisions, that can unintentionally provide some constraints on future trustees and beneficiaries. We do need to, as best we can, cast our mind forward, and that's an important part of the conversations that you will have with your professional. So a disciplined multi-decade perspective is going to support smoother intergenerational transitions. We do want to make things as easy as possible for those that are coming next. That's incredibly valuable for us. And when we have capital that's going to be managed with control that serves people and intent, estate planning becomes an exercise in optimizing rather than limiting any damage that can be done. We still need to think about those things, and there's lots of really good content that Kayla is covering off there. Stability creates better legal and also better tax outcomes for us. That's why it's valuable for us to be working through these particular phases. Behaviours in this life determine flexibility thereafter. So it sounds a little bit obvious, but worth saying that once things have happened, and this can be even before we've passed away, if we could spend a long period of time with poor health, we may lose capacity. So it's not something that we should necessarily put off too far into the future. It's worth thinking about it today, wherever wealth exists or is actively being developed. And then, of course, keeping these documents up to date as we move through. So capital stewardship is a phrase that I like to talk about. It covers the way that wealth is accumulated, the way that we protect that wealth during our life, and that directly shapes the effectiveness of what our testamentary arrangements are going to be. It expands the future flexibility when we are taking care of our finances now, because one of the outcomes of that will typically be that things are well structured and also well organized. Liquidity is very important. We can transfer both cash and assets into the testamentary trust, as was covered earlier. However, if there's a liquid portfolios and we don't have appropriate cash flow planning associated with those assets, yet we are trying to, for example, fund education or the needs of someone who has long-term care requirements, etc., it can force us into a little bit of a corner where you are almost in a forced progressive sale environment, and that can force some unfavourable decisions during that estate administration. There's nothing more concerning, I think, when we are left to fund a requirement that needs cash today, and it may be exactly the wrong time to be selling off a portion or all of that asset. So structuring liquidity within our plan is very important as well, and it's worth thinking about as we approach these stages of life. Finally, family governance. This is having those open conversations about the way things are, and sometimes these are really difficult and uncomfortable conversations. It's very much a useful approach to have those statutory declarations if someone is not to be included in the will for various reasons. It's important that other people know about these things within the family, and we may not have contact with the person, for example, who is not going to be included. But when as many people as possible understand, both from a written stat dec perspective as well as conversations within the family, what the expectations are, the responsibility is materially understood, and we're going to reduce the likelihood that disputes will arise. I think it's pretty difficult to make sure that we will completely eliminate the opportunity for disputes to arise, because we do our best at the point in time, but we're not sure what's going to develop thereafter. Therefore, that ongoing communication is going to strengthen how durable your testamentary trust framework is actually going to be for you through time. Tax efficiency. This is one of the things that comes to people's mind most often, probably alongside that asset protection there. But tax outcomes are going to deliver really good outcomes for us when we structure it well. So asset ownership, the way that our entities are structured, even debt positioning, and that's maybe something that we don't always think about as we are looking forward to our estate. We hope and imagine that debt may not be present when we're passing forward an estate. But in response to certain assets, it's actually beneficial to have the debt still consisting alongside the asset and the income stream from a tax perspective. So it can be there. So let's be cognizant of that. And distribution planning also is going to influence the eventual tax consequences. So ongoing financial discipline is going to enhance the structural efficiency. This is also where the relationship and the competency of the trustee that you choose is just incredibly important. I've worked individually with clients who have had varying results, and these are the recipients of testamentary trusts as a result of the decision that was made around, in this case, a professional that was attached as the trustee, a trusted family advisor of the generation above, and that hasn't worked out so great. They've got a large degree of lack of transparency. They do have legal remedies available to them. However, it's one of those things where they are very concerned about chewing up all the assets involved, or a large proportion of it, in taking that legal action. So it's very awkward. We do need to make sure we've got the best outcome for us, not just someone who's capable, but someone where we're comfortable about their character and their integrity, and making sure we understand them both in a professional and personal capacity as well. Simplicity. I've always a big fan of simplicity. Complex structures are sometimes required. That's a necessity of making sure we are managing sometimes our asset protection and our taxation effectively while we're here. But sometimes it can actually be the byproduct of growth that is not being managed well, where things are expanding rapidly and we're making decisions on the fly rather than stopping and engaging with those professionals in our life about how might this be appropriately structured. So it's best that we do have a deliberate strategy around that structuring while we're here, because intentional design through and over time is going to reduce any unnecessary tax friction. We do want to avoid that wherever we possibly can. And my favorite word about thinking about tax efficiency is actually optimization rather than maximization. We should think about what is most effective, because there are trade-offs. There's pros and cons with how we manage tax, and thinking through that is important, particularly as it relates to flexibility, as you can see there. Testamentary trusts are going to give you that discretion. They will provide control for what happens afterwards. However, the value is going to often depend on that financial architecture that we've structured beneath the testamentary trust. So behavior is going to create the space for our tax-aware decisions as we move through and into that planning. Preparing our heirs as well as our assets. This is something that I feel we should have more conversations around, and wealth without capability definitely does erode. So transferring capital, and particularly where there is large sums there, without preparing the beneficiaries is going to, I feel, introduce some long-term risk, potentially to the individuals who receive that income, who it might be detrimental for them, but definitely to the family legacy. So financial competence, as well as the capacity to take on those responsibilities, are essential components of maintaining legacy. So that's where I often find myself supporting that next generation coming through, even before the estate has passed along. If we can see and look 5 and 10 years down the track and see that there will be a transfer, we can begin to take the steps that give everyone confidence around how that wealth is going to be managed, not just structurally, but also in our mindset and how we approach that behaviourally. So values alignment, this is something that also supports the correct transfer over time and maintenance of that wealth. So our estate intentions, they're more likely to stick when we do have beneficiaries that understand both the assets that are going to be involved, as well as the philosophy. Why were they created? What are we seeking to support and achieve? And what were the intentions behind the person that we're actually receiving those funds from? So when we share that purpose as much as possible across the generations, it helps to stabilize our wealth. And finally, a little bit on intergenerational readiness, which I've partially touched on there, but proactive preparation is the key takeaway in this area here. That gives our heirs the best opportunity to be managing those distributions responsibly, focusing on contribution and meaning in their life rather than material wealth, is a good way to help them prepare. So education is also useful. Communication skills. One of the best things that we can do is have really solid relationships in our own life as well, because there's one of those big concerns is passing it where there is someone and maybe their spouse or partner isn't quite heading in the right direction, or there's some other issue there. So that's where we can, I guess, bolster the legal safeguards that we've put in place by having that effective communication and readiness in place. And finally, on these concepts here, financial freedom now strengthens legacy later. I believe that that's very true for ourselves. Is when we've got that sound structure, it's going to perform best when it's supported by the clarity around where we're going and how we are today, the discipline associated for ourselves as we manage assets in this lifetime as well as the next generation, and that long-term capital management, being able to look through time as best as possible about where we're going to be, because the decisions we make today will determine how things occur tomorrow and the degree of control and flexibility we've got, particularly around where the assets flow, what the tax efficiency looks like, and the outcomes that we hope to achieve for our beneficiaries. So as much as possible, taking a considered approach is something that's going to serve us well and serve our clients well. When wealth is managed with a greater degree of intention through this lifetime, and for me, being on purpose and intentional with our finances is such an important driver of the outcomes that we'll receive. Legal frameworks are going to be important for us, and that becomes hopefully the instruments that enable continuity rather than a sense of containment. And we feel confident about the structures, we feel confident about the people and the assets that we're flowing on to them for the future. For me, I did just want to briefly, beyond those comments, touch on what strategic financial well-being includes. It does start with thinking about income, because that is, I guess, the raw material from which we create wealth when it's well directed for that next generation and how we serve people in this lifetime. Often the foundations haven't been something that have been given due attention. And if we have foundations that are underdeveloped, we can end up with the financial equivalent of the Leaning Tower of Pisa. And we don't want our financial situation to topple over. So it is important to make sure we're continually giving attention to what those foundations look like whilst we are developing clarity, being on the same page, particularly as our partner or spouse, about where things are going and how we can structure ourselves to move to the next level. And for me, this is the level of thinking that I like to go to with clients as we move into the conversations, because when we are clear on the money side as well as the meaning side, it really serves us. Money is incredibly important and our financial circumstances do need to be well managed. However, money isn't everything. It really only has value in the context of human endeavor. So helping people think through these sort of elements, how we can structure on the money side our foundations, our freedom, and our growth, that supports and delivers the capability for us to be diving more into that connection, what that legacy looks like for our clients and for the next generations to come. Because legacy and that connection means aligning our finances with those relationships and thinking through how we're going to support those who are left behind. So this is perfectly aligned with the topic we're talking about today there. So both connection and direction is where we do spend a lot of time. It's tempting to think that if we get the money mechanics right, that everything will be sorted, but we do also need to pull the lens back and look at the somewhat bigger picture. And the way that I do that with clients, just in the final slide here, is actually a guided conversation about the key areas of their life. So you can see that out of those 7 areas are on the screen there, only one of them is financial well-being. The others all deserve attention. And this is how we, as a family, and as we cast our mind forward, sometimes a decade or more into the future, we're able to investigate those areas of life that are deeply meaningful for us, whether that is, how we look after our family and friends, or things, heart and spirit is, a little bit esoteric and it means something different to every person, but that can be how we support the community, which organizations or causes we intend to support moving forward. And all of that's a valid conversation as part of the overall thinking through our estate planning and the relationship with the testamentary trusts as well. So that's, I think, the main points that I wanted to communicate at this stage, Carly.
Wonderful. Thank you very much for that, Sloan. Obviously, it is a lot to think about for people, especially if they haven't turned their minds to it too much. I think, there's, you've spoken about different aspects in terms of, what are the key life areas and, how you go about making sure that, your assets are protected so they're going to who you want to and making sure that, the liquidity is there as well. So, and that all requires, proper planning. So obviously very important to probably, have a chat to you a bit further. I think that your details up there. If anyone does want a bit more guidance and help with planning their life goals, I guess. So thank you very much for that. I will mention as well, in terms of the estate planning type work as well, if you do need, some expert guidance, obviously, whether it be effective wealth and estate planning, it's not determined by, the legal structures alone. It's the quality of those financial decisions that are made over time. So, it's shaped by the clarity, confidence, and long-term thinking plays a critical role in determining controlled, tax-efficient outcomes for future generations to come. So, if you are looking to secure clarity and long-term peace of mind, more than happy to have a conversation with you, obligation-free, and you can receive, some personalised guidance tailored to your actual particular estate planning goals. And obviously, for the financial goals, have a chat to Sloan. There's a QR code there. If you do want to scan that, you can register, essentially set up that consult now. Otherwise, our team will reach out to you at the conclusion of this to try and arrange a consult to go through it all a bit further, because obviously I saw on the bottom of all Sloan slides that it's not financial guidance that is given, and same with legal. It's, unfortunately no one shoe fits all, so it is very tailored to each of an individual's needs as to what is going to suit them. So we'll open it up to some questions now. I did have one as well that popped up, which I told them I would answer at the end. So they've asked, how is a testamentary? And so, yes, sorry, if anyone's got any further questions, feel free to pop them in the chat box as this participant has done. Otherwise, take yourself off mute and happy to answer them. But the one we've got here is, how is a testamentary trust deals with or versus a family trust? So will the family trust come under the testamentary trust, or will it be separate? So essentially, a family trust is something that's in place straight away. With the testamentary trust, it actually doesn't come into play until the testator dies. So a family trust could be put into play, or come into effect, essentially immediately as soon as you create it, and you're going to be creating a family trust for different reasons. Now, in terms of drafting a will, we take into consideration various, different structures you've got in place, whether that be a family trust, whether that be a company that you're a director of or a major shareholder. So with a family trust, we would be looking at the actual trust deed to see who is nominated as the appointer. With the trust deed, we'd want to, make sure we understand what are the limitations or how we go about appointing a different appointer, because generally the appointer is likely going to be the testator, the one that's passed away, and we then need to put someone else in that role. So your will cover off on appointing an alternative appointer for your family trust. Different to a testamentary trust though. Your testamentary trust is going to come into play, only once you've lost capacity. You may not have a need though for a testamentary trust if you've got a family trust, but again, I can't answer that situation, without understanding, all your wants and needs with your estate. And, likely that's going to, involve as well speaking to someone like Sloan to get that financial advice as well, to understand, why was the family trust set up? What assets does the family trust hold? And then, what are potentially reasons why you think you might want a testamentary trust as well, because, that can be for a range of different reasons. So thank you for that question though. Hopefully that's answered it. But otherwise, yeah, reach out to Sloan and I, and happy to go through it in a bit more detail. There's no other questions in the chat box at the moment. Does anyone have any that they want to take themselves off mute for? I'll just give a minute or two before we wrap up, just in case someone's typing away or. I suppose one for yourself, Sloan. Do you find that there's a particular point in time that you like to start doing all this, planning? Like, do you work with a particular age group, or is it a particular event in someone's life, or?
The answer is both, Kaylee. So I do find the average age of the person that engages me or the couple tends to be mid-40s, which makes a lot of sense because we're starting to have assets that do need management and thought, or we're stepping into adding to our personal wealth at that particular time. It also coincides with our peak earning capacity normally, and generally our peak expenditure capacity too, when we've got kids going to private school and things of that nature. So it does require thoughtful and intentional action because wealth doesn't happen by accident. It's the result of conversations and looking forward and taking appropriate action for people. So yeah, I think that's the time. However, in relation to specific events occurring, they often will be occurring to people within their circle, not necessarily even family members, where someone else has been affected by something unexpected. It can be a health event or an accident, and it really sort of pushes us into action because we suddenly reflect, oh my gosh, that situation is similar to me. What would I do? How should we think about this?
I definitely agree with that. I think sometimes with estate planning, it's the same, it's like sometimes pulling teeth to try and get, client instructions and stuff like that. But all of a sudden, if they're going into surgery or they're going on this big overseas holiday, it definitely, or they've dealt with, death in their family or something like that, it definitely pushes them to move a lot faster, which, is not always, you'd rather deal with it, at the outset where they've got time and thought processes are happening, at a nicer pace. But yeah, it is the way it is with their
Yeah,
busy lives, I
correct.
guess.
It's good to be able to allow those conversations to evolve naturally and to have the time to unpack rather than sort of trying to deal with a compressed time frame because of a looming event that we need to deal with.
Wonderful. Awesome. Well, there's no other questions that have been put up. So I might, no, there might be one more. Can all of my children be trustees? So yes, the answer is yes. You can have more than one trustee. Obviously, we spoke about, you could be appealing something because of the trustees not dealing with something adequately. So, and, when appointing as well, trustees, how do you want to appoint them? Do you want them all to be acting, jointly, that they've all got to come to a decision? And then obviously, what are your family dynamics? Is that even going to be possible? Do you have, 5 children and that 3 of them don't talk to each other and 2 of them are located on the other side of the world and unlikely to be able to sign documents that that we as the lawyers need signed to be able to apply for probate. So yes, the short answer, but it again requires looking into it and delving into it a bit more to work out, what your situation is in terms of, the children and whether they could adequately take on that role amicably, I guess, and with some level of speed. Wonderful. Well, there's no other questions popped up there. I do want to say thank you very much, Sloan, for joining us today. I've got your contact details up here on the last slide. I love the catchphrase, be the boss of your money. So if that's something that you're wanting to do, then definitely reach out to Sloan. As I said, happy to have a consultation with you as well in terms of, your legal structures and the estate planning matters. You can reach us through our contact details listed here as well. Otherwise, we will try and reach out to you after the webinar to try and lock something in, and we will also send everyone a recording of this webinar and also the slides that go with it. So thank you very much again, Sloan, and thank you everyone for joining us.
Thanks, Callie. Thanks, everyone.
Have a good afternoon.